Honestly, I'm still not clear about what she is trying to explain because she keeps starting different ideas, but never completes them. So far, I've heard mixed claims, including that she was assaulted, that she has chlamydia, that a baby shower was arranged for her, that she walks like a model, and that someone threatened her with a Polaroid of her son to force her into committing crimes she denies. It all feels very confusing and hard to understand what is actually going on. It is difficult to follow her narrative clearly.
Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really. I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey. Captain Winfrey?
Captain Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
okay, so yes,
Lieutenant Grady.
It's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger. I was in danger, and there was a instance that happened in the car. But
I'll be honest with you. I'm still not sure what she's...
At this point, the judge decides to allow her to continue asking these unusual and unclear questions. However, there is a major problem. She still seems completely unsure about the person she is trying to question. Even though she is given the opportunity to proceed, she cannot properly identify or explain who she is referring to, which makes the entire situation more confusing in the courtroom and hard for everyone to follow. This leads to more hesitation and confusion as the exchange continues without any clear direction or understanding.
Is it your claim that someone from an inmate in the jail or another employee there
that may have
did this sexual assault?
That may have been the one to do. I don't know who the person was.
Where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet.
Let me rephrase. Did this incident happen inside the jail or outside of the jail?
Outside the jail, okay. But I was working with Fulton County at the time.
All right, so the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Okay. Do you have any reason to believe that he did?
Because if he's aware of the baby shower...
No, that's not my question, not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail because they have a picture of my son. They have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay, I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming, may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next?
Yes.
Okay, well, glad we're talking about it now then. All right, well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think the state's objection to facts, not evidence, is one that could very well come again.
Okay.
And we'll see where that takes us.
She returns to the common "that's not my signature" argument in an attempt to challenge the document in question. However, the complication is that in the same statement, she also admits that she did in fact sign an oath of office. This contradiction makes her position difficult to sustain, since both points cannot easily be true at the same time. It now becomes important to see how this issue is interpreted moving forward and what impact it may have on her overall argument in the case. This creates additional uncertainty around her claim.
Miller, can you summarize what exhibits are on the stack that are going to the jury?
Yes, Your Honor. What will be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the Caduceus report, and State's Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, Your Honor.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a copy of the oath?
If you've already got it, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office. I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else. I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure, I'm not too quite sure if that matches what I actually signed when I...
At this stage, the court proceedings reach a pause as the judge announces a 15-minute recess before closing arguments, with instructions to return at 1:50. This detail becomes important later because when the court reconvenes, the expectation is that both parties will be present and ready to proceed. However, as the hearing resumes, the situation changes unexpectedly. Only one party appears in the courtroom, while the other is noticeably absent, creating a new development that affects how the case continues.
To the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted, and there was no objection. So those being the only grounds, then your objection is overruled, and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, state's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm going to do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
So at this point, the jury is brought into the courtroom and the prosecution proceeds to present closing arguments on its own. During this phase, the defendant is not present, so the state continues without any response from the defense side. However, the defendant does eventually return, but only after the jury has already left the courtroom to begin their deliberations. This absence during such a critical stage affects how the closing phase is perceived and leaves the courtroom in a very unusual procedural position.
It's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in, and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing?
First of all, it is not the court's duty to ensure a defendant returns on time. The judge clearly instructed everyone to come back at 1:50, but the defendant did not return until around 4 p.m. Because of this delay, the court began to lose confidence in her ability to continue the trial properly without failing to appear again. As a result, the judge issued a bench warrant and ordered that she be taken into custody for the remainder of the proceedings. This decision ensured the trial could continue without further disruption.
Jury charges.
Yeah, that's hers.
Yeah.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag, if that's possible.
Okay, one second.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you could just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Prior Street, which is south of us, and made a left at Mitchell and Prior, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes, Your Honor.
And that's several blocks away from the courthouse. All right. Ms. Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you or did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Ms. Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting.
It was at this point that her sovereign citizen side really started to shine like the burnt-out light bulb that it is. Because while it may be news to some and not others, the courts have criminal, civil, and equitable jurisdictions. Criminal jurisdiction to hand out criminal punishments like fines and jail time. Civil jurisdiction to hand out civil punishments like monetary damages. And equity jurisdiction to hand out equitable or non-monetary punishments like getting an injunction to stop a builder from building on a particular property. There, now you've learned something today.
That's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked your bond, I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory minimum for possession of a Schedule I, Schedule II, or Schedule IV, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
you can't
no.
deny that injustice.
And that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum, are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no and then just reread the intent charge and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact.
She continues to insist on her fee schedule, but the court cannot properly address it while she keeps interrupting proceedings and speaking over the judge. Because of this repeated disruption, she receives back-to-back findings of contempt of court. Meanwhile, the jury is able to complete its deliberations and ultimately reaches a verdict. They are now prepared to return to the courtroom and deliver their decision. The court then prepares to formally read the verdict once all parties are present in the courtroom.
Refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice. I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done?
No, I'm not. Are you recontracting the trust?
You remember what I told you at the outset of this trial, which is that if we started getting into
You
it, you
haven't
started
answered the
interrupting
question.
me. All right, Ms. Young, I'm going to find you in contempt of court.
Are you
and
in
I'm
contempt
immediately
of
imposing a
justice,
20-day
though?
sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm
So
finding you
trying
in
to see how,
contempt a
as a
second
judge,
time, Ms. Young. That is an additional 20-day sentence I'm imposing.
you can do as you please because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you
please
cannot
escort Ms. Young
refuse.
from the courtroom.
Come
I
on,
find her
yeah.
as
You'll be hearing my
disrupting our
fee schedule. Let me put this up.
I got that.
And you know you're in contempt of justice.
So the prosecution is requesting that 3 of the charges carry a 15-year sentence, with 10 years to actually serve, while the remaining 2 charges would be 5-year terms served concurrently with the first set. In total, this amounts to about 10 years in custody, followed by 5 years of probation. While that already sounds like a significant punishment, what she ultimately receives turns out to be even more severe. And the courtroom reaction is tense as the judge outlines the final structure of the punishment and its long-term consequences. It marks a turning point in the case.